back to Cup Notes. On part 1, we have discussed the characteristics of criminal law, which are generality, territoriality, and prospectivity. We have also dealt on generality. We talked about the details of this. To remind you, generality refers to people, and it says that our laws are binding on people who live or sojourn in the Philippines. So it doesn't refer to Filipinos only, but to other citizens as well. So again, you have to associate these three things to concepts or words that you would easily remember. So for general, it's people. Territorial, it's for place. And perspective is for time, which is forward-looking. So ako na-associate ko siya sa drawing or ini-imagine ko yung taong nakatayo sa circle and naglalakad ng pa-forward or paabante. So in that way, nai-imagine ko itong picture na to and nare-remember ko. So to refresh your memories, generality refers to people, tao, when you say generality. And it says that penal laws are binding to all who live and sojourn in the Philippines. All meaning lahat ng tao na tumitira or nasa Pilipinas kahit na transiting lang or panandalian lamang. So, kahit na hindi siya Filipino, kahit na foreigner, na in transit lang, kahit na sa airport lang, saglit lang na dumaan sa Philippines, basta nasa loob siya ng Pilipinas, under siya ng ating criminal jurisdiction. I'd like to remind you also of the exceptions on the generality rule, which is treaties and laws of preferential application. So, dapat sa lahat ng nakatira or nagsusojourn, applicable ang criminal laws, except for those which are in the treaties such as the VFA and also sa laws of preferential application. So under laws of preferential application, we have RA 75 kung saan exempted ang ambassadors and ang household help, ang kanilang household help. And then letter B, we have the worship rule when we said that the worship of another country, whether it is in the Philippines, is exempted from our criminal laws kasi it is considered as sovereign. Parang extension siya ng country kung saan siya nakaregister or kaninong worship siya. And then lastly, we also have the principles of public international law, wherein the following are exempted from our criminal laws. They are not under our criminal jurisdiction. Sovereigns and other heads of state, charges d'affaires, ambassadors, ministers plenipotentiary, and ministers resident. So, siguro kailangan nyo lang i-memorize ito kung gusto nyo ma-master. But please take note, consuls are not included here. So, these are the under the principles of public international law. And going back to our topic of characteristics of criminal law, we have discussed about generality. It's time for us to discuss about territoriality, which refers to territory or place, and prospectivity, which is forward-looking, or we refer to time going forward or into the future. Take a few seconds to look at these three words or concepts so that you would be able to better master it or memorize it. We go to the number 2 characteristic, which is territoriality, from the word territory. So, meaning, ang penal laws or ang criminal jurisdiction ng Philippine criminal law is dito lang sa loob ng Pilipinas within its territory. So, it says that penal laws of the Philippines have effect only within its territory. Of course, enforceable lang siya dito. Kung nasa ibang bansa, ibang laws na. Kung nasa labas ng bansa, ibang laws na ang magpe-prevail. However, itong general rule na to, as I have said, meron laging exception ng general rule. So, makikita nyo ito sa Article 2 ng Revised Penal Code, which has the following exceptions. Ito, iisa-isahin natin. Number 1, should commit an offense while on a Philippine ship or airship. Number 2, should forge or counterfeit any coin or currency note of the Philippine Islands, or obligations and securities issued by the government of the Philippine Islands. Number 3, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Number 4, while being public officers or employees, should commit an offense in the exercise of their functions. And number 5, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2 of this code. Now, let's discuss them one by one. Number 1, should commit an offense while on a Philippine ship or airship. So, tandaan nyo, this is an exception to the territoriality rule. So, ang scenario is, wala siya sa loob ng Pilipinas. Nasa labas siya ng jurisdiction ng Pilipinas, pero nasa loob siya ng Philippine ship or airship. Ship is barko, airship, yan yung airplane. Ang term na ginamit noon was airship. So, ang keywords dyan is Philippine ship or airship. Ang requisites dito are, number 1, the crime is committed while the ship is treading in A, Philippine waters, which is intraterritorial, or the high seas, extraterritorial. Tandaan nyo, dapat nasa high seas. Kasi, kung nasa loob na siya ng jurisdiction ng ibang bansa, yung laws ng ibang bansa ang mag-govern. So, make sure that the ship is in the high seas. And then, number 2 requisite is that the ship or airship must not be within the territorial jurisdiction of another country. Na-mention ko na yan a while ago. So, it's either in Philippine waters siya or on the high seas. And then, the number 3 element is that the ship or airship must be registered in the Philippines under Philippine laws. So, ang nagmamatter ay yung registry. Minsan, may mga questions kayo may encounter. For example, doon nakadock yung ship sa ibang bansa or doon pinapark or kung ano man yung tawag doon. Basta ang tingnan nyo is yung registry. Yun ang magde-determine kung saan siya nakaregister yung word na registry. For number 2 exception, please take note that the ones to be forged are, number 1, coin or currency note ng Philippine Islands. And number 2, obligations and securities issued by the government of the Philippine Islands. So, think of coin or currency note and obligations and securities. The number 3 exception to the territoriality characteristic of criminal law is that should be liable for acts connected with the introduction of the obligations and securities mentioned in the preceding number. So, ang ini-introduce lang ngayon should be obligations and securities, hindi yung coins or currency note. And please take note, those who introduce the counterfeit obligations and securities are criminally liable, even if they were not the ones who counterfeited the obligations and securities. On the other hand, those who counterfeited the items are criminally liable even if they did not introduce the counterfeit items. So, please take note, huwag kayong makakonfuse, magkaibang liability siya. Sa number 2, kung sino man yung mag-forge or counterfeit ng currency note or coins, or ng obligations and securities. Ibang liability yon sa number 3 na nag-introduce into the country ng obligations and securities. You have to take note of the difference. Kailangan very observant kayo. Kasi usually, ang mga questions sa bar are very tricky. Minsan, kung hindi nyo nakita yung difference, bibigyan kayo ng question na akala nyo, tama yung sagot nyo, kung hindi nyo masyadong nakita or alam or master yung batas, then makakasagot kayo ng mali. Kasi medyo confusing nga. So, please take note of the difference para makasagot kayo ng tama. Number 4, while being public officers or employees, should commit an offense in the exercise of their functions. Keywords, public officers or employees. Usually, magkasama yan lagi yung phrase na yan. Please take note, memorize. Next, exercise of their functions. Ilang beses nyo rin makikita tong phrase na to, in the exercise of their functions. Parang package yan. Public officers or employees in the exercise of their functions, may encounter nyo rin yan sa administrative law. So, maraming mga crimes committed in the exercise of their functions like direct bribery, qualified bribery, indirect bribery, corruption, frauds against the public treasury, profession of prohibited interest, possession of prohibited interest, malversation of public funds or property, failure to render accounts, illegal use of public funds or property, failure to make delivery of public funds or property, falsification by a public officer, crimes committed in relation to the performance of a public officer or employee of his or her duties in a foreign country. So later on, may encounter nyo yan. It's enough na medyo narinig nyo lang siya once. And please take note under this provision also that embassy grounds are considered as extensions of the sovereignty of the country occupying them. So they are sovereign. Hindi siya pwedeng maging under sa criminal jurisdiction ng ibang bansa because it is sovereign in itself. So according to Minusher versus Court of Appeals, again, embassy grounds are considered as extensions of the sovereignty of the country occupying them. And the last exception in the territoriality rule is number 5. Should commit any of the crimes against national security and law of nations defined in Title 1, Book 2 of this Code. Crimes against national security are treason, conspiracy and proposal to commit treason, misprision of treason, espionage, and terrorism. While crimes against the law of nations are inciting to war or giving motives for reprisals, violation of neutrality, correspondence with hostile country, flight to enemy's country, piracy in general and mutiny on the high seas or in Philippine waters, and terrorism. Please note that crimes against public order, example, rebellion, coup d'etat, and sedition, committed abroad is under the jurisdiction of the host country. Hindi siya under national security and law of nations. So usually yan ang tricky question dyan. Isipin nyo na yung rebellion or yung coup d'etat or yung sedition, diba, it sounds like it is a crime against national security and it's a crime or a crime against the law of nations. Don't be tricked. It is not under this exception. Kasi under siya sa crimes against public order. It's enough that you have heard it once or twice. Ito naman, i-discuss ito thoroughly when we go to criminal law 2. As a review, the exceptions to the territoriality rule are the following. Number 1, should commit an offense while on a Philippine ship or airship. Number 2, should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippines. Number 3, should be liable for acts connected with the introduction of obligations and securities mentioned in the preceding number. Number 4, while being public officers or employees, should commit an offense in the exercise of their functions. Number 5, should commit any of the crimes against national security and law of nations defined in Title 1, Book 2 of this Code. So, please take note, yung mga medyo tinaasan ko ng tono, yun yung mga keywords that you have to remember. And now, finally, we are on the last or third characteristic of criminal law, which is prospectivity. So you just have to remember that prospectivity means forward-looking. Hindi siya retroactive. Nag-a-apply lang siya to the future. So in Article 21 of the RPC, it says that no felony shall be punishable by any penalty not prescribed by law prior to its commission. So kung ano lang yung mga applicable na laws during the time na ginawa mo yung crime or yung felony, then that's the time pwede kang i-punish. Hindi pwedeng i-apply sa'yo ang mga provisions na ile-legislate pa lang or magiging effective pa lang after na ng commission of the crime mo. So, ang pinakatitingnan natin dito is kung ano yung batas during the time that you committed the crime. There's an exception to the general rule that law should be applied prospectively. Laws may be given retroactive, kabaliktaran ng prospective, retroactive, pabalik. Retroactive application if favorable to the accused. So, kung halimbawa, mas bumaba na ang sintensya at nagawa niya few days, months, or years back, pwedeng i-apply sa kanya retroactively kasi favorable sa kanya yon, mas bababa ang sintensya niya. So, ang magic words is retroactive application, favorable to the accused. But there's an exception to the exception. That is, when the offender is a habitual offender or a recidivist. Kung paulit-ulit na siya sa paggawa ng crime niya, disqualified na siya dito sa retroactive application. So please take note, ang keywords or magic words are habitual offender or recidivist. So congratulations everyone, you have finally reached the end part of our review. So let us repeat that the characteristics of criminal law are: number 1 is generality, number 2 is territoriality, and number 3 is prospectivity. If you want to review the concepts, then just go back and replay this vlog. And I'd like to make another vlog, yung shortened version nito. Kapag naintindihan nyo na lahat ng concepts and lahat ng mga tinakle under the characteristics, then pwede nyo i-play yung shortened version just for mastery na lang to. Ang understanding is naintindihan mo na siya, ima-master mo na lang siya for memorization. Thank you very much for watching. I hope nakapag-subscribe na kayo and I hope nakatulong ako sa review nyo. I'll see you again. This has been Plantorni G. Have questions about the topic or there are other topics that you want me to cover, then just type on the comment below and I'll try to answer them as much as I could. And gagawa pa po tayo ng mga ibang vlogs para mas madalian po kayo na maintindihan yung mga lessons nyo. Again, thank you so much. See you again soon. And don't forget to subscribe. Please also hit the notification bell so that you're the first one to know whenever I upload new vlogs.